Sorry, last time we didn't have the interaction due to some unavoidable reasons. Today we'll complete the interaction and then questions, please. The interaction, as promised, is the second Sunday. Any questions you have to ask, please? Any doubts? Any doubts till the classes we have completed, sir? Any questions, please? We'll go ahead with the class, and if possible, if the strength increases, we'll go to the interaction again. Here, last time I was dealing with the law of leases. Here, lease is defined as where there is a transfer of possession of immovable property by one person called the lessor to a person called the lessee on the consideration of payment of rent, share of crops, annuities, or profits arising out of the business, and subject to a fixed term and subject to a superadded condition that once the purpose is accomplished or once the term comes to an end, possession has to be redelivered back to the lessor. So, first analyzing it, lessor is normally called as in the colloquial language as a landlord, and the lessee is normally called the tenant. Here, every contract can be supported by consideration. So the consideration is lessor or the landlord parts with the possession of the immovable property, and the lessee or the tenant comes into possession of the immovable property. Since every contract has to be supported by consideration, the consideration is rent, which is paid by the tenant or the lessee, share of crops if it's an agricultural lease, annuities, any amount that is payable per year, or what is called profits arising out of a business. It is called a lease. The person who transfers possession is called the lessor, and the person to whom the possession is delivered is called the lessee. And the consideration is the rent which is paid, share of crops, annuities, or profits arising out of the business. And then it's for a fixed duration of time. And once the time comes to an end, automatically the possession has to be redelivered back to the lessor or to the landlord. Here, we were also dealing with what is called periodic leases. As far as dwelling houses or office or commercial properties are concerned, it is supposed to be month to month. It is supposed to be month to month means the first, suppose let us say it's from first to the end of the month. It is from first to the end of the month, that is 31st or 30th, as the case may be. The next month starts on first of next month. If it is a Telugu calendar, it's Amavasya to Amavasya. Amavasya normally is 15 days behind the English calendar, but normally it is resorted to only by the Vaishyas, not by the other communities. But we normally follow the Gregorian calendar, that is what is called the English calendar. Here, as far as dwelling houses and commercial properties are concerned, the notice has to be given, and 15 days notice has to be given, terminating the lease, ending on the last day of the monthly tenancy, and asking the tenant to vacate and deliver possession on the next day. But here, amendment has been brought about. There's the only amendment in the Transfer of Property Act which says that it is not for the tenant to say when his tenancy commences, when it ends. But if 15 days notice is given, it's more than sufficient. It may start on any day, it may end on any day. That's the reason when you draft the notice, you say your lease is hereby terminated by so and so date or any other date which according to you is the last date of your monthly tenancy, and you are hereby called upon to vacate and deliver possession by next day, and failing which my client will be constrained to institute legal proceedings against you holding you liable for all costs and consequences incidental thereto. That's how the notice has to be worded, and this is as per the judgment of the Honorable Supreme Court. Here, the question is the only distinction between a statutory lease and a contractual lease is statutory lease, you cannot get rid of a tenant unless you come under any of the provisions of Section 10 of the AP Buildings Lease Rent Eviction Control Act of 1960. They're like what is called default, subletting, securing alternative accommodation, acts of nuisance for self occupation, for additional accommodation, for self occupation for business, self occupation for residence, additional accommodation when the accommodation is not sufficient for you. All these grounds are available under Section 10. And there also there is an embargo. Suppose the tenant is in the essential service, he belongs to the central government or the central state government, or in the state government undertaking or the central government undertaking, he cannot be evicted on the ground of self-occupation. But the exception is if the landlord also belongs to the same cadre, then in that case the preference of the landlord will prevail over the disadvantage which will be caused to the tenant. And one more thing you must remember is that, say, tenants securing alternative accommodation or cease to occupy for 4 months. Here I can give you an example. The case which arose in Chennai, what happened was the government placed with the policy of prohibition whenever they like, whenever they want. In Chennai, previously it was liquor free, but subsequently what happened was, I think if I'm correct, it was during unauthorized time, prohibition was introduced, whereby they say sale of liquor was prohibited. A person was carrying on liquor business and then he was having his bottles and all inside. But subsequently, because the business being declared unlawful, he had to close down the business. The landlord filed a case saying that the tenant has ceased to occupy the property. But the court in this case said is even if a single bottle or a box is found, it amounts to constructive possession of the property. Because of this activity being declared unlawful by the government, he could not carry on the business. It cannot be said that he has ceased to occupy the property. Please remember, sometimes the interpretation of words is very, very important for an advocate. For example, ceased. Ceased means the dictionary meaning is stopped, disbanded, abandoned, left. So many meanings can be given. In one of the cases, what happened was a father had only one daughter. Daughter was already married, and the father was a widower. He lost his wife, and he had to go to his daughter's house every day in the morning, have food there, had to take rest for some time, come back in the evening, and then again go in the morning like that. The landlord filed a case saying that the tenant has ceased to occupy the property. But here the court took the view saying that his samans or his articles are very much there in the property. He only goes there to have meals with his daughter. It cannot be said, yes, ceased to occupy the property. So sometimes what happens is dictionary plays a very important part. What interpretation you give to a particular word, sometimes you win a case or lose a case based on the interpretation which you give. Then like that, suppose that, and please remember, I also told you that justice varies according to the foot of the chancellor. Here in Karnataka and Tamil Nadu, it is very difficult to get rid of the tenant. Why? Because most of the judges are tenants in Karnataka and Tamil Nadu. Here, in suppose let us say a tenant commits default in payment of rent, straight away you cannot seek his eviction. What you have to do is you must file a money suit and then file an execution petition also, and take a certificate of non-satisfaction saying that in spite of the decree, the tenant has not paid the rents. Then based on that certificate, you file an RCC or what is called rent control case. That is a position as far as Karnataka and Tamil Nadu is concerned. But as far as our composite Andhra Pradesh state is concerned, or the subsequent Telangana state, the landlords, the rent act is mostly tilted more towards the landlords. Why? Because they say the interpretation given by our High Court is to say that so long as the right to property is recognized by the courts, a question of tenant dictating terms and saying, please occupy this property or occupy that property. When the landlord's ground is genuine, the tenant has no other option than to vacate and deliver possession. So here, the question is, it's mostly landlord-oriented judgments in our Andhra Pradesh, because the person who drafted the Rent Control Act was the ex-chief justice who had I don't want to give his name, and who had trouble with his tenants for 25 years. The matters went up to the Supreme Court, and the properties were at Kachigoda. Then he drafted the Rent Control Act in such a way that the tenants are thrown out in a jiffy. and it made it more easier to the landlords. But it's quite contrary to the preamble to the Rent Control Act, which says to prevent unreasonable eviction of tenants, this law called the AP Buildings Lease Rent Eviction Control Act 1960 is passed. But please remember, it is observed mostly in breach rather than in observance. But here, that is what is called a statutory lease. That is, your tenancy is protected by the statute called the Rent Control Act. But as far as the contractual tenancy is concerned, it is a purely out and out contract between the landlord, between the lessor and the lessee, and it is given for a fixed duration of time. You have no business to hang on to the premises once the tenancy comes to an end. That is the reason it is said you cannot compel an unwilling master to keep his servant in employment in whom he has lost confidence. That is the principle on which the contractual lease is based. So here the question is, lease deeds are. Please remember what is the difference between a lease deed and a rental agreement. Rental agreement is normally a unilateral document. It is executed by the tenant in favor of the landlord, and all the obligations are on the part of the tenant. But lease deed is a bilateral document. It is some of the obligations are on the lessor, that is the landlord, and some of the obligations are on the tenant, that is the lessee. And normally there's a practice, especially regarding commercial properties, the municipal taxes in respect of the madgi or the shop has to be paid by the tenant or has to be paid by the lessee, in addition to the rents what he pays. And suppose, let us say, it is in a complex, the maintenance charges also has to be paid by the tenant or the lessee. The lessor has nothing to do with that. So these are all the conditions which are incorporated in a lease deed, where there are respective obligations on the part of the lessor or on the part of the lessee, and it is signed by both of them and witnessed by two witnesses who attest the document. Periodic lease, as far as dwelling houses or commercial properties are concerned, it is supposed to be month to month. And normally, I think in the previous classes, some student asked me, sir, we take a lease for 11 months. Why should I get it registered? Well, that was the position before. 11 months, it doesn't require registration, but the stamp duty has to be collected. The stamp duty is 3% for every year. That is annual rent. Out of annual rent, 3% is the amount which is payable towards the stamp duty. And if it is more than 3 years and more than 5 years, it is 5% of the annual rent that is liable to be paid. And please remember, now the law has changed. Registration Act 17(1)(b) has been introduced by the Amending Act of 2001, effective from 1/7/2001, which says every transfer relating to immobile property which creates rights, extinguishes rights, releases rights, relinquishes rights, or creates rights in respect to the property, or reserving an annual rent has to be in writing and has to be duly registered. So that means even a lease for 1 month has to be registered. You cannot avoid payment of stamp duty. And once you don't pay the stamp duty, that document is not enforceable in court. Not only the stamp duty, but also the registration also you have to get it done. Suppose you take a rental agreement or lease deed on 100 rupees stamp paper. The duty that is payable, let us say, the rent is 10,000 rupees. 10,000 rupees into 12 will be 1,20,000. 1,20,000 is, that is if you take 3%, is somewhere around 4,000 or 5,000 rupees, which has to be the stamp duty has to be paid accordingly. But you pay only 100 rupees. 3,900 will be collected towards the deficit, plus the penalty which is levied is 10 times the amount that is liable to be paid. Sometimes it will be a very, very, very heavy expenditure. Please bear one thing in mind, that the litigation under the transfer of property is a very heavy proposition. Why? Because when you have to file a suit for eviction under the TP Act or the Transfer of Property Act, you pay the court fee on the annual rental value plus the amount which you have received at advance. Both of them have to be consolidated, and then you pay the court fee under Section 40 Clause 2 of the Court Fees Act. And suppose, let us say, you make a mistake or a faux pas somewhere regarding the notice, please remember your client has to forego that amount what he has paid as court fee. Second thing is, one more thing you must remember, sir. Suppose arrears of rent is also due, the tenant is due the arrears. The same suit in the second prayer, you should have to say, for arrears of rent of from so and so to so and so at the rate of so and so, and future rents at so and so. Then third one is, suppose the tenant continues to be in occupation of the property in spite of a quit notice being served on him, then he becomes liable to pay damages and compensation, and that is in legal language called mean profits. MESNE. S is silent. Mean profits. That is what rent the property can fetch in case the tenant vacates. What are the prevailing rents in the locality for similar accommodation, for similar location, so on and so forth. That is the damages and compensation that is payable as mean profits. And mean profits are from when he has to pay. Suppose, let us say, I give a notice on 1st of January 2024. I terminate the lease by 31st of January 2024 and ask the tenant to vacate on 1/2/2024. Then after 1/2/2024, till 1/2/2024, I am entitled to the rents. But after that period, 1/2/2024, what is receivable by me is only mean profits. That is damages and compensation, popularly called mean profits. And that has to be ascertained, that has to be fixed by the court at the time when the inquiry takes place. And when you file the suit also, suppose let us say you file the suit not on 2nd, but you file it on 10th. That 8 days period, you calculate the proportionate mean profits and also pay the court fee on that proportionate mean profits. So this is an expensive affair, but as far as the Rent Control Act is concerned, the amount what you spend towards court fee is only 2 rupees on the eviction petition. But here in the Transfer of Property Act, you pay the court fee on the annual rent plus the premium which you receive. And the proportionate mean profits also, you pay the court fee separately. And also the arrears of what you're claiming, you pay court fee separately. And one thing you please remember, in the Civil Procedure Code, there is a provision called Order 2, Rule 2, that says splitting of claims. That is, suppose you are entitled for arrears of rent, you don't claim it in the suit, you cannot file a separate suit in respect of the arrears of rent. That is, you cannot split it up. One day you file a suit for eviction, the other day you file a suit for arrears of rent, other day you file a suit for mean profit. That is not permissible. Claim everything in one. You cannot split it up and file separate suits. Multiplicity of suits is prohibited as far as Order 2, Rule 2 CPC is concerned. Then we see the periodic lease. Suppose, let us say, the lease deed is for 11 months or lease deed is for 1 year. Then let us say, here 15 days notice has to be given terminating the lease by a particular date, and the last date of monthly tenancy, ask him to vacate on the next day. Suppose the lease is for 3 years, let us say. Sometimes there is a special clause also there. In case either party wants to put an end to the lease, it shall be done only by 3 months notice, advance notice on either side in writing. That means you have to adhere to that condition. That is to say, 3 months notice, whether you like it or not, you will have to give 3 months notice. Then one more thing you must remember is, suppose it's agricultural, manufacturing, industrial, or educational institutions, it is supposed to be year to year. That means 6 months notice has to be given as far as these leases are concerned. Why? Because the question of difficulties will arise as far as the lessee is concerned to find alternative accommodation. Then along with that, I'll also be failing in my duty if I don't give you the provisions of the Civil Procedure Code, which guarantees your rents. That is, new sections have been introduced by 15A1 and 15A2 CPC by the Amending Act of 1976, whereby it is said that in case arrears of rent is due on the date of suit, you can always file an application under 15A1 and ask the tenant to pay the rents or deposit the rents into court, whatever is the arrears, and continue to deposit the rents every month at the admitted rate. And suppose, let us say, in spite of the order, the tenant does not deposit, then under 15A2, you can file an application before the court to strike out the defense of the defendant and also put you back into possession of the property summarily. That is what is called new provisions 15A1 and 15A2, which has been introduced by the Amending Act of 1976. And please remember, one thing is this almost akin or similar to Section 11 of the Rent Control Act, which says you cannot contest an eviction petition unless you pay the rents. Please remember, you can say, sir, mean profits you are claiming, why should I claim rents? No. Yeah, the question is so that the tenant may not escape payment of rent and run away from the place without paying the rents. These provisions have been introduced. Then, as far as periodic leases are concerned, dwelling or commercial properties, 15 days notice has to be given, calling upon the tenant to vacate on the last day, terminating his lease by the last date of monthly tenancy, and ask him to vacate on the next day. But suppose, let us say, there is a special clause there, 3 months notice has to be given. That 3 months notice, whether you like it or not, it has to be given. And that's the reason a clever advocate, what he does is, he introduces one more clause, notwithstanding anything contained above, if the tenant commits, the lessee commits a default of 3 consecutive months, he is liable to be evicted without further notice. Then, as far as agricultural leases are concerned, manufacturing leases are concerned, industrial leases are concerned, educational leases are concerned, 6 months notice has to be given. So, this is as far as what all we have done yesterday. Then we go further. Then we go further by dealing with one not eight. Yes, 106. 106, what I dealt with just now, notices. Then 107 deals with leases, how made, how a lease is drafted. I told you, lease, unlike a rental agreement, is a bilateral document. It is by and between the lessor and the lessee. What happens in a lease, sir? The lessor delivers possession, lessee takes possession. Lessor, by virtue of giving possession to the lessee, is entitled to what? Is entitled to rents, is entitled to share of crops if it's an agricultural lease, annuities, any amount that is payable every year, or profits arising out of a business. If the lease is for a lease is where you become a partner, or the profits which arise, you also get a share in the profits. So here, how a lease is made. First and foremost is this lease deed executed at Hyderabad on this day of so and so, by and between Mr. So and so, son of so and so, age so and so, occupation so and so, resident of so and so, hereinafter called the lessor, which term shall include all his heirs, assigns, and legal representatives, and Mr. B, son of so and so, age so and so, resident of so and so. So, next para is whereas the lessor is the owner and possessor of house number so and so, admeasuring so and so square yards, by virtue of having purchased the same from so and so through a registered sale deed bearing document number so and so. Whereas the lessee has requested the lessor to let on rent the premises bearing number so and so on a monthly rent of rupees so and so. Next para. Whereas the lessor has accepted the offer of the lessee and agreed to let out the tenanted leased out premises on a monthly rent of rupees so and so. Next para. Whereas the lessee has this day paid the lessor a sum of rupees so and so towards advance and earnest advance rent, which some shall, or security deposit, which some shall be refunded after adjustment, subject to settlement of accounts. Next para. Whereas this lease has commenced on so and so date and is for a period of 1 year ending on so and so date. Then next part. Now this deed of lease witnesseth as follows. Then you give the obligations of the lessor, then you give the obligations of the lessee, and also the lessor signs and the lessee signs, and witnesses also attest the document as having witnessed the execution of the document. And every lease which previously it was annual rent, now every lease has to be in writing and has to be properly stamped and has to be duly registered after the amending provision 17(1)(b) of the Registration Act. Please remember one thing: a lease deed is normally signed by both. It is a bilateral document. It is witnessed by two parties. As far as agriculture leases are concerned, it is from year to year. There's a share of crops, whatever is payable to you in the form of kind, it will be mentioned in the lease deed. Then manufacturing purposes, there also heavy amount is taken towards deposit, and that will be refunded at the time of settlement of accounts. As far as educational institutions are also concerned, there also deposit is taken, and you specifically mentioned for what period it has been given. This is how a lease is made under section 108. 109 deals with rights of lessors and lessees. Rights of lessors and lessees. And what are their liabilities? Here, what is the right of rights and liabilities? What is the right of the lessor, sir? The lessor has got a right to receive the rents every month as per the terms and conditions laid down in the lease deed. Second is the lessor is entitled to protect his property by preventing the tenant or the lessee from subletting the property. Third one is lessor has got a right of directing the tenant not to make any additions or alterations without his written consent. And the fourth one is these are all the rights of a lessor. What are the rights of a lessee, sir? Rights of a lessee is quiet and peaceful possession, then entitled to a receipt for payment of rents, and is entitled to occupy the property for a particular purpose. Fourth one is so long as the lease subsists, he has got a right of being in quiet and peaceful position and his position not being disturbed. These are the rights and liabilities of the seller and the lessor and the lessee. Then we go to section 109, that is rights of lessors with transferees liabilities. That is, here, suppose let us say under 109, suppose A and B are there. B is the tenant and A is the landlord. And let us say the tenant continues to pay the rent to A. And subsequently it turns out that A sells the property to C. Then in that case, whatever rents are paid to the old landlord by the tenant, he need not pay it again to the new landlord. This is what 109 says. That means it's also a possessory title. Here you cannot deny the title of the landlord, however defective it may be. He is the person who has inducted you into possession. You are the person who is answerable to him, and you cannot set up title in a third party and say, I will pay the rents only when your rival claims are settled. Once you dispute the title of the landlord with a defective title also, you lose the right of questioning the notice and remaining in possession of the property. And one more important thing under 109 is that attornment. Attornment is till such time the tenant is attorned or the lessee is attorned to a new landlord, he continues to pay the rent to the old landlord, he will not be called upon to pay the rents over again. Then next one is 110. Exclusion of day on which tenancy has commenced. Tenancy term commences. Suppose let us say the tenancy has commenced on first. The tenancy month starts from the next day. That is from second to the end of the month. So the question is the day on which the tenancy is created is excluded for the purpose of calculating the tenancy month. They're all academic sections, please. Then 111 is very important, sir. Most of us think that there are two words, determination and termination. Determination and termination almost look similar, but they are different. Why? Because determination means suppose I give a property to you, deliver possession to you, it is for a fixed duration of time. Once that time comes to an end, the tenancy also comes to an end or the lease comes to an end. This is what is called an 111A, efflux of time. Suppose I give it to you for 1 year. Once that 1 year period comes to an end, your lease automatically gets determined. No notice is necessary once it is subject to time. Are you able to understand this? That is efflux of time. It is given for a fixed duration of time. Once that period comes to an end, automatically the lease also gets determined. I'll give you a classical example, though it is not regarding immobile property. Suppose in open land, usually you have this Deepavali season and you have this fruit season also. Suppose open land is given to a person to carry on his business. It is given only for that season. Once that season is over, he has to deliver possession back to me. He cannot claim rights in perpetuity. That is called efflux of time. Second one is that is, it is said time limited conditionally. That is time limited conditionally. That means 3 months time only I've given it to you. So long as the Sitafor business is there, Crackers business is there, or any other business, and it is given to you temporarily on the condition that once the time is over, you have to redeliver possession back to me. Then once that time comes to an end, automatically the lease gets determined. And third one is merger of interest. What do you mean by merger of interest? That means where you sell the property to the lessee himself, and the lessee purchases the property, the position of the lessee becomes that of the landlord or the owner. He need not pay the rents to the landlord or the his erstwhile landlord. And in that case, where the tenant and the landlord becomes merged, where the tenant purchases the property, by that the lease automatically comes to an end. The next one is where the interest of the lessor terminates or his power of disposal of the same extends only to the happening of an event by the happening of that event. Suppose, let us say, the lessor's right comes to an end because it is dependent upon his position, depends upon the happening of an event. Unless that event happens, a question of if the event does not happen, the lease automatically comes to an end. Then merger of interest, then surrender. What do you mean by surrender? Surrender is of two types. One is called express and another is called implied. Surrender means every landlord will welcome it. Suppose the tenant says, I don't want, I got a better premises, sir. This premises is not sufficient for me. I'm vacating it. Please take possession of the property. That is what is called, in writing he puts it, it is called express surrender. But if by implication he keeps everything open, removes all his sammans, then keeps the premises empty, it means it's an implied surrender and he does not want to continue the property. And next one is that is next one is forfeiture. Forfeiture means where the tenant commits or the lessee commits the default as per the terms and conditions of the lease, he is not entitled to stay there anymore. Then in that case, he incurs what is called forfeiture, or in Hindi they say zapt hona, రద్దు చేయడం అనేది forfeiture అంటారు. So forfeiture is when he violates the terms of the tenancy, terms of the lease, or uses the premises for a purpose other than for which it is leased out, then in that case he incurs forfeiture and his tenancy comes to an it gets determined. And then 112 deals with waiver of forfeiture. Suppose, let us say, a notice to quit has been given, and let us say the landlord and the tenant enter into a fresh agreement whereby the rent is increased. Suppose it's 5,000 rupees, it is made into 10,000. A fresh document comes into existence. Then, in that case, it is deemed that the landlord or the lessor has given up his rights as far as forfeiture is concerned. That is a waiver. That is maaf karna or condonation. Then waiver of notice. Suppose, let us say, no, the 113 deals with waiver of notice. Suppose notice is given to quit, but after that the landlord and tenant enter into an agreement whereby the rent is increased. Then let us say in that case, whatever consequences follow by the quit notice gets waived, gets condoned. That is 113. Then 114 is specifying the breach. One important thing is whenever you give a quit notice, when the tenant has violated the terms of the lease, you must also specify on what grounds you are seeking eviction. What are the grounds he has violated? What are the conditions he has violated? How he has committed default? How he is using the premises for some other purpose than for what it has been given, or he has sublet or assigned his tenancy right. These grounds will have to be specifically pleaded. Then last one is that next one is 115, the effect of surrender and forfeiture. The under lessee, no prejudice to the under lessee. Please remember, the main tenant goes. Suppose the landlord receives the rents from the under lessee means subtenant. Then in that case, even though the notice may be given, the under lessee is protected. These are all the provisions which deals with leases. And then as far as agricultural leases are concerned, they shall be suspended. That is, this chapter does not deal with agricultural leases. As far as agricultural leases are concerned, they are governed by the Tenancy Act. In case you want to get rid of a kauldar or a cultivator or a tenant of yours who is cultivating the lands on your behalf, then you will have to proceed under the provisions of the Tenancy Act, but you cannot proceed under the transfer of property, and this chapter does not apply to agricultural leases. So this is as far as law of leases are concerned. Then we go to the small chapter called exchange. Just excuse me, please. What do you mean by exchange? Exchange means ownership of one property is exchanged for the ownership of another property. Ownership of one property is exchanged for the ownership of another property, and such a transaction is called a exchange. And right of the party deprived of the thing exchanged. Sometimes what happens, the only thing you can exchange is property. You cannot exchange your wives. Here the question is, the ownership of one property is exchanged from the ownership of another property. It is called a transaction of exchange. Please remember, the person who transfers the ownership is not called the exchanger. He is called the same transferor and transferee. Ownership. Please remember, A owns property X, Y owns I, B owns property Y. Y is exchanged for property X. So mutual exchanges take place. This mostly takes place regarding the brothers, not outsiders. Then here, as far as suppose let us say the property exchange has got a defective title, whatever money has been spent to clear the defects, the person who has exchanged that property or the person who has given this property to him is to compensate the person who has taken a defective title. Then the next one is the rights and liabilities, same rights and liabilities which arise in the transaction of sale also applies to exchange. And exchange of money, there is genuineness of money. Please remember, you have to be very, very careful, sir. I think I still remember the parallel currency also is in circulation. I was told demonetization was done to prevent fake currency coming into the market. But please remember, sometimes you see the fake currency, it looks more genuine than the genuine currency. Here, I was told, they also showed it in the TV also. They said, with the color xerox, you can make out currencies also. But somewhere you make a mistake, because if you see the currency carefully, you have got the wires in the middle. And wires are on both sides. But in a fake currency, you don't have the wires. But here, normally in the petrol bunks and all, what they do is they got a machine, they put that in that machine, infrared rays, and they find out it's a fake currency which has been passed on. So the question is, as far as exchange of money is concerned, the genuineness of the money is important. Suppose it's a fake currency, then the question is the transaction is void. So this is as far as exchanges are concerned. Then we go to the next chapter called gifts. In gifts are called in Telugu as Danamu, or in Urdu it is called Tofa. That is anything that is given free of cost without any consideration except by through natural love and affection between blood relations. It is called a gift, or it is done what is called gratuitously without any money being exchanged. So gift is been transferred is where there's a transfer of immovable property by a person called the donor to a person called the donee out of natural love and affection or gratuitously. It is called a transaction of gift. Gift is a very unique transaction where you don't have giftor and giftee. There is no such English word at all. But the word that is used is donor and donee. And please remember, gift is supposed to be a bilateral document. It is. Please remember what are the essentials of a contract: offer and acceptance. Offer of gift and acceptance. So offer by the donor and acceptance by the donee, and signed by both the parties in token of the offer and in token of the acceptance completes a gift. And every transaction of gift of the value of 100 and above has to be in writing and has to be duly registered. You can ask me one question, sir. When there is no consideration passed, when there is no money passed, where is the question of paying the stamp duty? But please remember, they say in Telugu, Devudu varamichina pujari addu chadani. Government is interested in collecting its revenue. That is the reason a gift deed is also compulsorily registerable and proper stamp has to be paid. Of course, the stamp duty is very less. As far as blood relations are concerned, it is 1% to 3%, and outsiders are concerned, is 5%. But the most essential ingredient of gift is that it is a bilateral document. The offer of gift and acceptance by the donee completes the gift, and that is the reason why the donor and the donee, both of them sign, and it is attested by two witnesses. And the transaction is called a donatio, or it's called a gift, and it's a bilateral document. Please bear that in mind. Both the donor and donee have to sign. The donor in token of gift and donee in token of acceptance. And I just remember one maxim, the earliest maxim in the Contract Act: an acceptance is an offer, what a lighted match is to a train of gunpowder. Suppose you have a train of gunpowder, so long as it's not ignited, there's no explosion. But once you light a matchstick, a big explosion takes place. Not even a single particle of gunpowder can be formed. So that is the effect of acceptance. Acceptance, once done, it cannot be broken, it cannot be revoked, it cannot be taken back. So that in same way, as far as a gift is concerned, the offer of gift and acceptance completes the offer, and it becomes a contract. And every transaction of gift, even though it may be free of money, or it is gratuitously out of natural love and affection, it has to be properly stamped, and it has to be duly registered. Then the question arises under 124, sir. Here it is said, gift of existing and future property void for, as far as present property is concerned, gift can take place. But future property, that is, I still remember a joke in one of the movies where Brahmanandam says he goes to an advocate and wants a will to be wants a will to be drafted, and he tells the advocate, sir, 10 acres of mango gardens, 10 acres of tamarind trees, 10 acres of so and so, so and so, so and so, and all. Then he says, sir, what is the value? He gives a value also. Then where are the properties? Where are the documents? He says, no, I have to earn the property just now. I'm going to get it in future, not now. So please remember, a property which you don't have it immediately, there cannot be a gift. And a future property which is to come to you later, you cannot execute a gift deed or enter into a transaction of gift. Only present property which is in your possession, which is within your disposing capacity, only those properties can form part and parcel of gift. And next one is gift by several of whom one does not accept. Suppose, let us say, that is, it is said that to avoid the extent of where it does not accept. Suppose a property is given in two halves to A and B, and let us say B does not accept it. Does it mean that the gift in favor of A will fail? No. The person who can take it, and the person who does not take it, well, that fails. Then when revoked or suspended, the donor and donee may agree on the happening of any specified event which does not depend upon the will of the donor donor shall be suspended or revoked, but a gift which the parties I agree shall be revocable wholly or in part at the mere will of the donor is void. Suppose, let us say, the donor says, I will revoke the gift at any time. I reserve my right to revoke the gift. I take back the gift. I'll cancel the gift. That cannot be done. But the question is, it can be kept in suspended animation till that event happens. Suppose he says, I'll give this property to you by gift, provided you marry C. So, on the happening of that event, the gift stands. But suppose he says, you do not marry, the gift will be suspended. That cannot be done, sir. Because it is dependent upon the uh, will of the donor. Then 125 is onerous gifts. Onerous gifts means where a gift is in the form of a single instrument. Some of it here, suppose, let us in a single instrument, different properties. Let us say the property is given, and some of which are burdened on the liabilities. The ones does not take unless you. Suppose two properties are given. Let us say one property is free from encumbrances, but the other property is burdened with encumbrances, that is, liabilities are there, but a single instrument, only single document. Then in that case, the question is either you accept it in full or reject it in full. You cannot say, I will take the property which is free from encumbrances, but as far as the property with liability is concerned, I'm throwing it out. You cannot do it if it is in a single instrument. But if it is in distinct instruments, one instrument, second instrument, then in that case, you can accept the property which is free from all burdens, and reject that property which is full of liabilities. This is called onerous gifts. Then we go to what is called universal donee, where the gift consists of whole property of the donor. The donee is personally liable for debts to the extent of the property gifted. Suppose the entire property of the donor is gifted, and some of the properties are burdened with obligations, but it's a single instrument. The donor does not retain anything except a small portion for his maintenance. Then, in that case, whatever liabilities are there in respect of the documents, the donee has to discharge those liabilities. And such a donee is called a universal donee. And next one also is the donatio mortis causa, DONATIO space, mortis, MORTIS space, causa, CAUSA. That means a gift made in anticipation of death. Please remember, there are three occasions when a person becomes a saint. Once a person is in the deathbed, he is going to die any moment. Nothing but truth comes out. And he is very, very philanthropic and charitable when he's in the deathbed. Then he calls his, what is called, his daughter-in-law and the daughter to his side and says, "You have served me very well till now. I want to compensate you and gift you something." Then what he does is he takes an old Parker pen, which is about 100 years old, and gives it to his daughter-in-law and says, "This is a very valuable pen. You cannot calculate it in terms of money. Please keep it as a present on my behalf." And as far as some other articles are concerned, he gives it to his daughter. But let us say these donees to whom the articles movable property, please remember, immovable property cannot take place. The question is, as far as movable property is concerned, mere delivery. But let us say the donees who have found that the donor in his lifetime has not even donated a pin. He was so conjuice or he was so selfish. He didn't do anything, but all of a sudden he has become charitable. They die even before the donor because out of shock, they get a heart attack and they die. Then in that case, the gift gets resumed. There is no question of the gift taking effect. That is what is called donatio mortis causa. Donatio in anticipation of death, or a gift in anticipation of death, only regarding movable property. Mere delivery of possession is sufficient. No writing is required. No registration is required. But it's very, very rare. So that finishes the chapter on gifts. Then the last chapter, I think not last chapter, there's other small provision which we have to deal with is what is called actionable claims. Actionable claims is dealt with from section 131 to 131 to 135, 136, 131 to 136. What do you mean by an actionable claim? That is, a transfer, 130 says, a transfer, whether for consideration or not, shall be effected by an instrument in writing signed by the transferor, and then all rights vest with the transferee, and he can sue on legal claims. Mostly, if you come to the courts, sir, I think all of you are advocates. You can find people hovering around courts. They are very, very noted or notorious for purchasing litigation properties. As far as sometimes what happens is, the fellow gets vexed. Then he says, let me hand over this or assign this promissory note or assign this decree to someone. And suppose, let us say, you have to record about 50 lakhs. Then a person comes and says, "Sir, I'll purchase it for 30 lakhs. I'll give you 30 lakhs hard cash. You assign the decree to me, transfer the claim to me, or transfer the promissory note to me, or transfer the document which you have got, which you can proceed against the debtor and recover your money. You can do. I will take all possible steps on your behalf, and please transfer it." Then in that case, the person concerned, the transferor, what he does is he assigns it. That's why it's called a negotiable instrument. He assigns it in favor of the assignee, the person who purchases that actionable claim, and for all practical purposes, he becomes the creditor, and notice is given to the debtor. Sir, from this day onwards, this man is going to be your creditor. You pay off all the amounts to him. This is how an actionable claim is transferred. But an instrument is required where you draft out in a form of an assignment deed saying that whatever rights you had in respect of that document, you are transferring it to B. That is what is called an actionable claim. A claim which gives rise to an action in a court of law is what is called an actionable claim. That means it can be a promissory note, it can be a check, it can be a title suit, it can be a mortgage suit, it can be any type of suit where your rights you transfer it to an assignee or a person who purchases your rights, and such a person is called the assignee. You reduce it in the form of an instrument, get it properly registered, and then file it in the court. So you get transposed in the place of the original plaintiff or the original decree holder, as the case may be, and you can proceed against the debtor as if you are the creditor. And the doctrine of privity of contract does not apply. Please bear that in mind. Are you able to understand this? And this is also called chose in action. Chose in action is, chose means thing, in action. That is, whatever is in action, you step into the shoes of the creditor by assignment, and those rights being assigned to you, or that claim being assigned to you, and for all practical purposes, you step into the shoes of the assigner, and you can sue the other person based on that assignment. That is actionable claim. 131 is notice to be in writing. There is notice has to be given to the debtor, and it has to be signed both by the transferor and the transferee. Then liabilities of the transferee same as transferor. Then 130 warranty of solvency. So at the time of assigning the debt, at the time of transferring the debt, and at the time of handing over the document, the transferor says, please look, the transferee is very, very solvent. You can recover the money. There's no unsafeness in the transfer. You can do it. Then he gives the solvency only to the date of transfer, not afterwards. Then next one is mortgage debt. 134 deals with mortgage debt, where the debt is transferred for the purpose of securing a debt so transferred is received by the transferor, is received by the transferee. The cost by payment for recovery and residue belongs to the transferor. That means, suppose let us say, instead of A bringing the suit, it is transferred to a mortgage debt is transferred to B. Whatever cost is incurred, whatever expenditure is incurred to recover the debt, on the understanding between the transferor and the transferee, that amount has to be made good to the transferor. That's what 134 deals with. And 135 is assignment of rights of policy of insurance against fire. Here, it belongs to the transfer. Suppose, let us say, a property is insured against fire, destruction or damage. So, whatever compensation is receivable from the insurance company, it is assigned to the transferee, and the transferee can claim that compensation and reinstate the property in the original shape. And then, incapacity of officers. Please remember the last section is very, very important, sir. An advocate, a judge, or a sports staff, or any person connected with the administration of the judiciary cannot participate in the transfer of actionable claims, or brings, or let us say, cannot participate in the spoils of the litigation, or cannot buy a negotiable instrument, or cannot get the negotiable instruments assigned in his favor, or cannot get the decree assigned in his favor. There is an express provision on 136 which says these people are all disqualified. They cannot bid in the auction. They cannot purchase a property. They cannot what you call acquire an actionable claim. Also, this is what 130 to 136 deals with actionable claims. Please remember, from the practitioner's point of view, this is not very, very important. Though it is in the Transfer of Property Act, we have to deal with it. So with this, we have finished the law of leases, law of exchanges, law of gifts, and law of actionable claims. That is, we have finished from 105 to 136. That is nearly 30 sections we have completed. Why I have dealt with these small topics first is the bigger topic is there, the giant is there, mortgages and the different kinds of mortgages. And only I'll give an introduction and stop with that. Here, before going to sales, we'll go into mortgages. Mortgages is dealt with from section 58 to 104, 58 to 104. Here, in the agency area, mortgage is called the Tanaka, and in Telugu, because we are half Telugu and half Urdu, here we call it as Girvi. Here, where please remember again, I take you to the Contracts Act. There's something similar to it, law of pledge or law of pawn, where in law of pledge or law of pawn, where movable property is offered as security for the due repayment of a loan, it is called a law of pawn or it's called the law of pledge. and the person offering the movable property as security is called the pana, and the person to whom the movable property is offered as security is called the is called the pani, and the goods which are offered as security are called pawned goods. And please remember, 3 years period is there within which you must pay the money and you can get back the jewels, or it mostly arises in the case of gold loans. But here in the law of mortgages, mortgage in section 58 has been defined as where interest in specific immobile property is delivered by a person called the mortgagor to a person called the mortgagee for on the consideration for securing a debt paid, promise, part paid, or part promise. The person offering the property as security is called the mortgagor, and the person to whom the property is offered as security is called the mortgagee, and the property that is offered as security is called the hypotheca. Here, it involves two or more parties. Who are they, sir? Mortgagor and mortgagee. Then for what purpose a mortgage can arise only regarding money matters. And for what purpose, sir? To secure a debt, secure a loan which has been given. And what is the consideration, sir? Consideration which in respect of a loan paid, promised, or part paid or part promised. What is the significance of part paid and part promised, sir? When you go to a bank, when you apply for loan limits of working capital or any other facility, there the limits you ask for a loan of 1 crore. Not that the bank is going to give you 1 crore immediately. They release it in stages. First they give you 10 lakhs, next 10 lakhs, 10 lakhs, 10 lakhs, and all. And they also take collateral security also from you. So the question is, when the primary documents are executed like promissory note, etc., they are called primary documents. And also there is a what is called pledge of stock and pledge of raw materials, etc. And then the collateral security is immovable property which is offered as security. And when the release is loan in stages, documents are taken only initially, not every time. And that is the reason it is said that paid, promise, part paid, or part promise. And here you must remember that there are 6 different kinds of mortgages. One is called a simple mortgage, another is called a mortgage by conditional sale, another is called an English mortgage, another is called a usufructuary mortgage, another is called an anomalous mortgage, and another is called mortgage by deposit of title deeds. This we shall discuss it in the next class, that is tomorrow. Now I'm keeping the house open for interaction, please. Any questions, please?
Any more questions? Mr. Natraj.
Yes, sir.
Yes, sir. Please go ahead.
A Hindu husband, he purchased the land and registered the land in the name of his wife.
Right.
Okay, and after the death of his wife, he made a will in the name of only one son. He is having 3, children.
Right.
He wrote one will in the name of only one child, one son.
Right.
My question is, what is the validity of the will?
As far as the will is concerned, it will operate only regarding the share of the husband. That is the A who has executed the will. But
he wrote the full property.
Pardon, sir?
He wrote the full property, not his share.
He cannot write the whole property because he can write only his share. That is 1/4. The other three people who are there, they can always claim partition and say the will is inoperative because our shares he has no business to will it away.
And how the bill is registered, sir? How the registrar can register the will without checking the ownership?
Not necessary, sir. But the question is that it must be a mistake committed by the registrar. But the question is, when it's a wife's property, only his share can execute a will, not regarding the other shares.
Okay, even though he purchased it with his hard-earned money.
Whatever it is, then in that case, wife is not alive. The question is, he cannot even initiate a suit for saying that it's a Benami transaction. The other 3 people can always challenge that will and
say not valid.
Not valid, exactly.
Any more questions? Sir, any more questions? Please go ahead.
Shall we wind up, sir?
Sir, will is totally ineffective or at least 1/4 of the
No, regarding 1/4
share
it
goes
may
to the-
regarding 1/4 it may be valid, but regarding the other 3/4 it goes by succession. That is, the other three sons get their shares.
No, sir. Since the will is written for the full property,
If it is
so by
rejected,
default, will be null and void.
now if it is rejected and declared as null and void, then the question of the partition opens. That is, all of them will have to get their shares divided.
So there is no question of only 1/4 property.
No,
given for the-
not so, sir. Not so, sir.
Right.
Miss Priya,
It as if the will was not written. Right. Thank you.
Yes. Sir.
Miss Priya, please go ahead with your question.
Yes.
Sir, Miss Priya is asking, may I know how the probate is done, sir?
See, as far as probate is concerned, probate is done only in presidency towns. As far as Hindus are concerned, probate, that is under 217 of the Succession Act, probate is not necessary. But if an executor is there and executor writes to the banks or people who have to pay the money not to make the payment to the beneficiary till they hear from them, then the bank accounts are frozen. Then in that case, probate is necessary. When the bank writes, please obtain a probate from the proper court. And the proper court is the district court. And the district court can grant probate. There is letters of administration or probate, as you may call it. But as far as Hindus are concerned, probate is not mandatory. But as far as Christians are concerned, letters of administration is mandatory because it comes under the testamentary transfer.
Miss Priya, you can ask on the open court. If you have a second question, please unmute your mic and you can go ahead with the question. Miss Priya.
Yes, madam.
She's hesitating, I hope so.
I think your question is
So
answered.
she is not able to speak. And the second question is, what is the provision for filing a suit for position of the immovable property?
As far as the position for filing a suit for immovable property is concerned, like any other suit, you assert your title and say that you are the actual owner of the property. Some other person has come into possession of the property. You want the court to declare you as the owner of that particular property based on your document. And please remember, under the provisions of Section 34 or the specific relative fact, when you ask for declaration of title, you must also ask for possession if you are not in possession. That is 34 proviso.
Any more questions? So what is the provision of law as per CRPC?
Provision of law for what?
Priya, you need to complete the question. CPC.
Provision of law for recovery of declaration of title, isn't it?
Surfacing.
Surfacey.
Is it for surfaces, Ms. Priya? Ms. Priya.
Yes.
No, sir. No, for provision. For position.
Surfacey proceedings are normally initiated by the bank. Bank tries to first attach the property. Earlier it was done through the recovery officer, but now it is done through the court, and normally the sub court or the principal senior court is the proper court which is nominated, where you have to take first you must file a petition there and then ask the court to appoint a commissioner, and the commissioner goes to the spot in the presence of the bank officials and the police and takes possession of the property and then files a report into the court that possession has been taken and bank is in possession of that property. That is the surfacing proceedings.
Sir, 1 second, sir. Priya, are you clear with the question? Or else, please repeat your question, we can answer it. Are you clear with your question? You got an answer? Ms. Priya. I didn't get any response. Right? Any more questions? Sir, I want a provision of law for position of immovable property.
As far as recovery of immobile property or possession of immobile property is concerned, It is like recovery of possession. It only lies under section 26, read with order 7, rule 1 CPC. But the court fee which you pay for recovery of possession is under section 29 of the Court Fees Act. You pay it on the market value of the property or 3/4 of the market value, whichever is higher. Or if you want to just ask for a declaration, then you can ask for declaration and possession. And suppose you are in possession of the property, you pay half the market value as court fee. And if you are not in possession of the property, you pay the court fee at 3/4 of the market value. That is under 24(1)(a) and 24(b) of the Court Fees Act.
Any more questions further? Or can we conclude the class for today? Please mention your question. If you have any questions, please mention it. Sir, I think Anuradha. Anuradha, you can go ahead with the question.
Yes, madam. Yes, madam.
Ready, what is the less? In lesser, what is the premium? I didn't understand the question. Lease.
Lease is supposed to be where.
Anyway, she is asking like this, sir. Yeah. Sir, in lease, what is the premium?
Premium means the advance what you take, the goodwill what you take. Or suppose you take 6 months rent in advance, that is called a premium. Of course, good, what do you call it as pagadi you don't mention. Pagadi is a thing which you don't mention. None of them mention it. But advance what you take, that is called the premium, sir.
What is the definition of? What is the definition of a lessor?
Lessor is called the landlord, a person who is the owner of the property. Lease is defined as where there is a transfer of possession from one person called the lessor, that is the landlord, to a person called the lessee, that is the tenant, on the consideration of payment of rent, share of crops, annuities, or profits arising out of the business, and for a fixed duration of time, subject to de-delivery of possession once the term comes to an end. It's something like bailment.
All right, thank you. Any more questions, or can we conclude the class for today? Can we conclude the class for today? Thank you. Thank you very much. We'll see you tomorrow again.
Thank you, sir.
Thank you.